Welcome to Tiemann Defense. Whether you're facing a misdemeanor or a felony charge, your arraignment hearing is your very first court appearance, and it sets the stage for your entire case. In this video, I'll break down exactly what to expect at an arraignment in California, what your rights are, and how the process differs between misdemeanor and felony cases. An arraignment is the official start of your criminal court case. It's when you're formally told what criminal charges have been filed against you. It usually happens within a few days of an arrest if you're still in custody. If you've been released or posted bail, your arraignment date is listed on the release paperwork you received when released. At the arraignment, the judge will read out the criminal charges against you. This is your official notice of what you're being accused of. Next, you'll be asked to enter a plea. You can plead not guilty, guilty, or no contest. Most people plead not guilty at the arraignment, even if they plan to resolve the case later. This gives your defense attorney time to review the evidence and negotiate if needed. In felony cases or more serious misdemeanors, the judge may review own recognizance or bail conditions. The judge will consider things like the seriousness of the charges, your criminal history, or whether you're a flight risk. In more serious cases, the court will impose supervised release terms, which requires you to check in with a probation officer while your case is pending. In cases with victims like domestic violence, battery, or theft cases, the judge may impose a criminal protective order or conditions which include staying away from a certain person or location, GPS monitoring, or search terms. In drug and alcohol-related cases, the judge could impose conditions which include installation of an ignition interlock device, alcohol monitor, self-help meetings, drug testing, and no alcohol terms. Ultimately, a judge decides what conditions to impose. In felony cases, you must appear in person. Typically, 2 court dates will be set at the arraignment, a pre-preliminary hearing and a preliminary hearing. The pre-preliminary hearing is a settlement conference, and the preliminary hearing is a contested hearing to determine if there is enough evidence to proceed to trial. In misdemeanor cases, your attorney can usually appear on your behalf, so you don't have to go to court. The exception is in misdemeanor domestic violence cases where a criminal protective order will be issued. After the arraignment, a future court date will be set called an early settlement conference. An arraignment might feel intimidating, but knowing what to expect and having a good criminal defense attorney fighting for you makes all the difference. If you're facing charges in Northern California, call us at 916-939-3900 to speak to an attorney.